This is an examination of the hidden human condition.
This is the Hidden Killers Podcast.
The Hidden Killers Podcast.
With Tony Bruschi.
Retired criminal defense attorney Lori Hellis joining us right now. We're going to be talking about the case against Bryan Kohberger. I know you've been following this from the very beginning as well. Kohberger's arraignment earlier today. Where do we go from here?
Well, Idaho's interesting. I moved to Idaho to write the book about Vallow. So certainly the Kohberger case is on my radar. Idaho is interesting because most states prefer grand jury, the grand jury format. Idaho, on the other hand, has a preference for preliminary hearings. And you might recall that in the initial charges for Chad Daybell, they actually held a preliminary hearing on the initial charges that were destruction of evidence and hiding of evidence. And so it wasn't until one of the reasons there was such a delay in the Vallow case was because COVID hit and the courts shut down and they weren't able to convene a grand jury for almost a year. Mm-hmm. So, but the prosecution decided to convene a grand jury in order to keep the witnesses and the testimony confidential because a preliminary hearing would have been public. Mm-hmm. And I think that was the same decision that was made in Kohberger. Because Idaho favors preliminary hearings, I think just as a matter of course, they set a preliminary hearing. But I'm not sure that the prosecution ever really intended to go forward with a preliminary hearing. I think they always intended to convene a grand jury. It's a high-profile case. Some of the pleadings just asked to have the grand jury, the witness list from the grand jury sealed because of some of the threats and some of the harassment that's happened for witnesses who appeared. So I think it's going to be the same difficulty of a small town community managing an extremely high-profile case.
Why now? Why was the grand jury convened just a month before where we were about to see the preliminary hearing?
I think it may just have been the discovery process, the process of putting together all of this already really voluminous information, all of the GPS coordinates, the DNA information, all of the phone. These kind of cases these days, because of technology, it means that the data that gets produced is enormous. The Vallow case, they were talking about terabytes of information. So I think it may simply have been they got to the point where they had their case sufficiently corralled that they felt comfortable making a presentation to the grand jury.
Mm-hmm. Now, in terms of information that will be coming out, a lot of people are jumping at this going, great, this is just in a few days. But this doesn't necessarily mean that we're going to be hearing a whole heck of a lot of new information. If anything, we'll probably be hearing less as we lead up to what if there's going to be a trial, depending on what he pleads here next week. Is that correct?
Well, that's absolutely right. An arraignment is a very perfunctory and brief process. So he'll go in front of the judge. They'll ask him if he has seen a copy of the indictment, if he understands it. In some states, the judge or the clerk actually reads the indictment to the defendant and asks the defendant if they understand the charges. This is the only purpose of arraignment, is to assure that the defendant has received and understands what they're charged with. Once that is done, they're going to ask him to decide on how he's going to plead. He'll enter a plea of not guilty at this point, and they will set a preliminary hearing or a scheduling hearing out a week or two, and they'll get all the lawyers together and they will determine whether he's going to waive his speedy trial rights, and then decide whether or not when they'll set a trial date. So we're not going to get any information other than a new date to set a date.
What's been your opinion on the gag order in this case? Obviously, the media wants it lifted. That's a given. But you also see the Gonzalez family wanting it lifted for the family members of the victims as well. Is this a good idea or a bad idea?
Well, I think there's a bit of a misconception, and I don't really know quite where it's come from, although it seems to me that it's coming from the Gonzalez family, because there was a conference about the gag order, and the judge made very clear that the gag order did not apply to the families of the victims. It only applied to the attorneys. So I don't really know at this point what the Gonzalez family's beef is. I certainly understand what the media's beef is. And it's such a tender balancing act. And I think it's easy to get it wrong. And I think that judges err on the side of, I'd rather be too strict than not strict enough.
Mm-hmm.
I think we all found it frustrating that there actually was a gag order in the Vallow case. Believe it or not, it was sealed.
Really?
So there was a gag order. We just didn't know about it. At least in the Kohberger case, things are being done a little bit more in the open in terms of court filings, because the court in the Vallow case sealed probably half of the documents and the proceedings that were happening in that case. Mm-hmm. But the Kohberger case, at least we're seeing it play out in it transparently. So I understand that there is this very fine balance. I think in the Vallow case, we were all pretty frustrated with the fact that the Freedom of Information Act in Idaho has an exception that does not allow release of documents pre-trial while a case is still under investigation. Arizona doesn't have that exception. So when the media filed their FOIA requests in Arizona, they got this massive dump of information from both Gilbert and Chandler police departments. And it included most of what was in the Idaho investigation as well. So a lot of people were pretty frustrated with the fact that all of this information was locked down until the Vallow case, until the trial. Mm-hmm. And when we went to trial, we all sat there and thought, well, none of this information is new. None of the information that the prosecution declined to release was new, because we'd seen it all from Arizona. Sure. Now, of course, we're not going to have that in the Kohberger case, because it all happened in Idaho. And I understand the frustration of the media not being able to get access to the courtroom and not being able to get access to the files and documents. On the other hand, I also was a prosecutor, and I understand the frustration of trying to put a case together and be able to pick an unbiased jury in the face of this incredible amount of publicity. I mean, international publicity. Yeah. How many of your listeners are in other English-speaking
exactly.
countries and the Netherlands and New Zealand.
Mm-hmm.
And,
No, it's shocking. I mean, it's like, I'll look at charts sometimes and be like, oh, we're number one in Saudi Arabia today.
Yeah, right.
It's like, okay, I guess they like to know about Kohberger. But yeah, it is interesting to see, just worldwide, the attention that exists to some of these cases. As a former defense attorney, I'm sure you look at it from that lens on that case as well. It looks pretty damning, from what we've seen thus far. Is it as damning as everyone thinks, the case against Kohberger?
I think this is a very different defense team, and I think that you are going to see them mount a much more full-throated and assertive defense than you saw in the Vallow case.
Mm-hmm.
I think that this team has already shown that they are on top of it. I mean, within hours of being appointed, they had their own team on the scene. And I think from the beginning, they have been much more assertive in the way that they have started to prepare the case. So I think you're going to see a very different defense. I think you're going to see many more questions about the scientific evidence, about the information that's produced by the FBI. I mean, there are questions about the technology the FBI applies in the way that they read these cast and make and read these cast reports. There's a lot of question about whether or not they're literally applying a different equation, a different scientific formula and algorithm to the same data we've always had from cell phones. And they claim that they can locate a cell phone in some instances within a 5-foot radius. That's what got the Vallow case, was the fact that they could locate Alex Cox literally within 5 feet of JJ's burial site.
Sure.
But there have been a lot of challenges to that cast information and the way that that data is analyzed. And that didn't come up at all in the Vallow case.
What have some of those challenges been?
Pardon me?
What have some of those challenges been to that way of going through the data?
Well, I think that there was at least a challenge to be made to the scientific process. Anytime we are admitting scientific evidence, whether it's DNA or whether it's the breathalyzer in a DUI case or whether it's cast data, you really have to be sure that the reliability of the results is dependent on the process and the scientific data. And if it's based on junk science, then you're going to get junk results. So there certainly was an opportunity for them to say, other courts have called this process of the way that we read the data into question, sufficient that it at least should have been raised at trial. Mm-hmm. And it wasn't. I think you're going to see that in the Kohberger case. I think you're going to see them go back and take a hard look at all of the science associated with these findings, from the DNA on the knife sheath to the GPS and phone data. I think you're going to see a much different approach defense-wise.
With what we know thus far, what would the advantage be of waiving the right, just to have more time for preparation, discovery, and building up that defense? Or what are the pros and cons in your mind?
Well, the pros are the faster that you go to trial, the quicker you put the prosecution to the test, and the less time they have to build their case and to continue investigation. Because investigation and the prosecutors will continue to investigate this case until the day the jury is seated. So the less time they have, the better from the defense standpoint. Mm-hmm. From the defense standpoint, delay usually works in the favor of the defense. Memories fade, witnesses die. I mean, any number of things can happen. And it also gives them sufficient time to find solid experts who can review all of the data that has been, the discovery that's been provided to them, and to really comb through the discovery and be sure that that they've really overturned every stone in trying to find holes in the prosecution's case.
This is an examination of the hidden human condition.
This is the Hidden Killers Podcast
with Tony Bruschi.
Lori Hellis, retired criminal defense attorney. Thank you for joining us and giving us your insight this week on both the Daybell case and the new developments in the Kohberger case. We do greatly appreciate you being on the show. If you like the podcast, be sure to press subscribe wherever you download podcasts. You don't miss any breaking updates or discussions on these cases as we continue to dive into them. My name's Tony Bruschi. Stay with us.